sort of our Labor Law 101, kind of a background primer on what the act is, what the board does, what it covers, how it covers you even if you don't have a union. So now that we've kind of got that done, you mentioned the shift and how depending on what administration we're dealing with, the laws tend to be interpreted differently. So now that we have this new board, let's talk about recent developments. So what do you think is the biggest pro-employer thing that's come out of this new board so far?
I think the appointment of the new general counsel. So the new general counsel, or I should say that the general counsel of the National Labor Relations Board is really the individual who sets policy. Because even though the NLRB is very openly political, it tended to shift. It was a little bit more pro-employer during the Republican administration, a little bit more pro-union or pro-employee during a Democratic administration. But it straddled the line one way or the other. Yet under the last administration, there was a very radically pro-employee, at least from the perspective of those of us who are our practitioners. The new general counsel said those are the categories of cases where he wanted his office involved, as well as some other areas where he wanted his office involved. And I guess we're going to talk about some of those.
Thing that he immediately did was rescind all of the previous memoranda relating to handbook rules and all those other rules. I think that's probably one of the biggest, most practical effects to employers.
Certainly, and that's one of the big issues. We talked earlier, there's certain policies that are going to be unlawful regardless of who the NLRB is and regardless of who the general counsel is. A policy that prohibits the discussion of wages, a policy that prohibits the joining of outside organizations, i.e. unions. I mean, those are unlawful under Section 7, regardless of who's up there.
Always going to be unlawful. Yeah, that's never going to be.
However, there are ones that are a little bit more subtle.
Right.
Like, for example, policies about demeanor and decorum, the way you conduct yourself at work. I mean, the last board took the position, and the last general counsel took the position that being abrasive at work, being abrupt,
not disrespectful,
being disrespectful.
There were a lot of words that became real keywords for read very broadly would limit your rights.
Under Section 7, that's right. And so we see a reining in on some of those policies. Yeah. Social media policies had to be very carefully drafted. We're starting to see a little bit of a reining in on that. Policies dealing with, for example, photography at work. The prior board had ruled that that was an unlawful practice to prohibit employees from taking pictures. The current board in the Boeing decision, they've said under the right circumstances, you can prohibit employees from taking pictures at work. If you justify from a business perspective the purpose of the rule, it makes it easy for the board to determine its lawfulness. It was a lot harder for them to try to guess on the back end what you had in mind. Go ahead and let people know on the front end why, from a business perspective, say a confidentiality rule is important.
That makes sense. To sort of craft your rules to say we're not going after union activity. In the case of hospitals, for example, we need to protect patient privacy, which is the reason we don't allow photographer. We have to comply with HIPAA. To actually have that in the forefront, that makes sense. It would be more likely to be found lawful. All right. So handbook policies, one good thing that's coming our way. Okay. Next up, something else that I think is, a major shift from an employer's perspective, Purple Communications. Tell me about email.
Purple Communications is the email case. Yes. All right, so Purple Communications was decided under the last board, the Obama board. And again, for those of y'all who missed it, we tend to refer to the board by the sitting president. And it's not a pejorative term, it's just how we refer to that collection of individuals. But under the Obama board, Purple Communications had reversed a prior decision. And the prior decision basically said this: if you, the employer, own the email system and you set the conditions for the email system, well, then you can prohibit employees from using the email system for their own personal purposes, like, for example, I don't know, organizing a union and sending out union cards to everybody. Purple Communications reversed that. And what they basically said is that employees use email for all sorts of purposes, and even though it is provided by the employer, even though it is paid for by the employer, ultimately it is such a fundamental part of the working environment that yes, employees can use it for whatever personal purposes they want, including trying to organize a union from the inside out by sending out mass emails to prospective union members.
Right.
And so obviously from the perspective of a management side labor lawyer, that was concerning to us. It was concerning to our clients. But the good news is we've at least seen some evidence that the board is reconsidering Purple Communications.
Right. And I think one of the things that's interesting about Purple Communications is because it sort of took a weird perspective on property rights. Technically, if it's my client's email, it's the employer's email, then they own that email. Things that go out with their little company name.com, I mean, that's theirs, that's their property. So the idea is that employees had essentially a property right in that email and the right to be able to send it and to control the content of it without the employers having anything to say about it is a little concerning. That kind of opens the door to a lot of other things. You know, at what point do we have the ability to prohibit discriminatory conduct? You know, at what point do we actually get to go in and say these are obscene materials and we don't want them in there, if you still have this idea that the employees have this sort of property right to their emails? It could have been a slippery slope, and it was one of the reasons we were concerned as well.
Exactly, but we do anticipate a shift and a change in that rule, which takes it back to if the employer pays for the email system, if it's the email domain of the employer, then the employer can set reasonable rules on how employees use it. Now, having said that, let me give you the caveat. You have to be consistent.
Absolutely.
Right?
Yeah, I was about to say, let me tell you how you can still get in trouble.
Correct. You know, I mean, when it comes to practical legal advice or practical advice, let me just tell you that if you can remember the first 5 letters of the alphabet,
Okay.
you can generally avoid most labor and employment problems. A, B, C, D, E, and it stands for always be consistent. Document everything. You know, I suggest put it on a 3x5 card, laminate it, make every one of your supervisors keep it in their pocket, because if they don't know what to do, be consistent and document is never a bad course of action.
We're still waiting to hear ultimately that Purple Communications is going to finish up, and the board was accepting briefs. That time period has expired, so fingers crossed.
We're just waiting on a decision.
That's
The
right.
fact that they're soliciting briefs, though, is
Right.
generally a good sign to us.
Right. Yeah.
Because if they didn't care about changing the law, then they really wouldn't care what we thought.
Very good. Another thing, joint employers. So that's been kind of all over the place lately.
Well, so here's the concept of joint employer, and we see it in a lot of different contexts.